Hello, all. Welcome to another session of Legal Essentials for Human Resource Management, a course which is curated to provide a legal acumen to everybody who handle work force, especially who handle people at workplace context. Over the weeks, we've been discussing about various aspects of work and related legal mechanisms. And now we are discussing misconduct. In our last session, if you remember, we defined what is misconduct, what are the types of misconduct, how do you classify something as a misconduct, employment misconduct to be specific. How do you define something as employment misconduct or not? So, we have covered all that. Now let's get into another interesting topic, which is how to draft charge sheet or showcase notice. So once a misconduct happens, after a small preliminary investigation, the next step is to provide a charge sheet or showcase notice. So we look into how to do that, what are the principles that you should be following while designing or rather curating a charge sheet or a showcase notice. So that's what we are going to discuss today. And I hope you remember my name by now. It's Dr. Amir Samulopanan, and I'm from Nalsa University of Law, Hyderabad. Now, so that we are clear how the entire process happens, let me show you a small flow chart. So let's say a misconduct is being reported. It could be a complaint from another person, or it is a suo moto action taken by the employer after noticing a misconduct. It could be any of such things, but a misconduct has been reported, and a preliminary investigation is being conducted just to ensure. Most cases it is not required if there is enough proof, so there is no need for this formal investigation. If not, sometimes if it is an accusation by a co-employee, you need to just verify the facts prima facie, and then you realize there is some merit to the case, you issue a showcase notice. And once the showcase notice is issued, some time is given for the accused employee to respond to the showcase notice. And then, depending upon his explanation, sometimes if matters are very clear with his explanation, then you may not even have to go for a domestic inquiry or a disciplinary inquiry. But if it is not satisfactorily explained or defended, you move ahead with a disciplinary inquiry. You will appoint inquiry a single person, or you could have a committee also for the inquiry. They will investigate the matter. We'll all get into that inquiry processes in probably our next session, and then submit a report telling whether the person in question here is actually committed this misconduct or not. And based on the recommendations of the inquiry committee or the inquirer, the inquiry person officer, we would take a disciplinary action as a punishment or a disciplinary action for the misconduct that has been committed. Sometimes the disciplinary inquiry will yield a finding that the person has not committed the said misconduct. If that's the case, there is no further action taken. But if the reports given suggest that the person has committed a misconduct, then the employer takes a disciplinary action, which can even be termination of employment. So it all starts with a showcase notice, or rather what we call as a charge sheet. So let's look into the details of what is the charge sheet, what is the showcase notice. So to give you a small introduction, a charge sheet is a memorandum of allegations which are leveled against an employee who commits a breach of any rules, regulations, standing orders, or the terms of contract. So essentially, at the nutshell, it is a memorandum of allegations. You write down all the allegations. We are not calling it list of misconducts because we don't know if the misconduct have actually happened or not. So it's a memorandum of allegations, all the allegations that is leveled against this employee, and this memorandum is called as the charge sheet. Now the objective of the charge sheet is derived from the principle of or a legal principle called as the other side must be heard. Before taking any actions, you need to hear the other side also, and that is the principle on which the entire charge sheet is built on. Now, a charge sheet is given to a delinquent employee, as in the accused employee, so that he understands all the allegations against him and has an adequate opportunity to defend himself. That's why charge sheet is very important. You tell the accused employee, the delinquent employee, that this is what you have committed and this is why it is wrong, and this warrants some punishment according to this clause, and then you give it to this delinquent employee. He will also understand, maybe he didn't do this act, maybe there is some defense for this act, but he should understand what is a charge leveled against me, and this charge sheet will provide a clarity to this delinquent employee. And that's why a charge sheet has to be very precise, and it should have all the particulars that lead to a fair and transparent disciplinary inquiry. Why this is very important is that generally the courts do not involve into the decisions of a internal domestic inquiry, except for the fact that this principle of other side is not heard. If that principle is violated, if the courts feel that that principle is violated, they will definitely intervene. And that's why there is a need for the charge sheet or a showcase notice that should be issued, which is also very precise and contains all the allegations against the person on which you are about to take action. You should not just hide few of them and then give the showcase notice and later take certain decisions based on that hidden misconduct perceptions. Then the poor accused person, the poor delinquent employee didn't have enough scope to defend his defend allegations against him. Now let's look at what are the essential ingredients of a charge sheet. So when you custom build a charge sheet, you need to ensure that all these principles are maintained so that later it will not be challenged in court or in any other way. There is an opportunity for the delinquent employee to raise a concern that it was not a free domestic inquiry that has happened. Before getting into all that, please do understand the reason why we stress upon the fact that you should be very, very carefully following the law as well as the procedures while conducting domestic inquiry, is because if you don't follow all the legal guardrails, if you don't maintain the compliance, often terminations and misconduct related terminations are challenged in the court. Often they are, if you look at majority of these cases, they are always related to termination of the employment, because termination due to misconduct is always a red mark in the career of an employee, and the employee will definitely fight with all his might to ensure that such a red mark does not exist in his service history. So definitely things would be challenged in the court. So you have to ensure that these principles are maintained while drafting a charge sheet, so that later you're not challenged in the court. So first principle, or the first thing that you should be aware, or rather the first essential ingredient, is that a charge sheet must be drafted in a simple and unambiguous language. So you should not just use complex legal words in the charge sheet, and later it shouldn't happen that the delinquent employee raises a claim that I didn't understand what was the charges that is leveled against me. So it has to be a very clear, precise, unambiguous language which clearly sets out all the allegations leveled against the complainant, against the delinquent employee. So clearly mention all the all the allegations that are leveled against this particular delinquent employee. The employer also should ensure that the charge sheet is translated in a vernacular language which is understood by the delinquent employee. You are not comfortable in Marathi, but the delinquent employee is only comfortable in Marathi, then it is the responsibility of the employer to issue the charge sheet or a showcase notice in that particular language that the delinquent employee understand. So that's the first thing that you should be careful about. There should not be any vagueness in the charge sheet. That's also very important. So the charge sheet should convey to this delinquent employee the exact nature of charges, and it should not be assumed that the employee will understand the charges through his alleged understanding or knowledge of the charge. So, you just casually mention something and then you think that no, employee anyways knows this is what he have done. And you don't mention the major act which due to which you are charging him. Nothing that comes in the charge sheet does not comes under the the purview of the inquiry. It can definitely be challenged later. So you have to be extremely clear in drafting the charge sheet, and there is a risk that this charge sheet can become invalid. So is the entire disciplinary proceedings, because it is built on a charge sheet that is extremely vague, and because of that any findings can also be deemed null and void. So a small, unclear, or rather a vague charge sheet can actually derail entire effort you have put it into the domestic inquiry. Honorable Calcutta High Court in Amulya Ratan Mukherjee versus Deputy Chief Mechanical Engineer case, here the petitioner could not specifically refute the charges and defend himself, as no particulars had been given in the charge sheet. So that was the defense of the delinquent employee, that I wanted to defend myself but I couldn't, because they were not specific about what are the charges against me. So the court clearly said that if it is not clearly mentioned, it goes against the principle of other person has to be given a chance to explain charges against the person. And if that fundamental principle is violated, court might interfere and say that the proceeding is null. So you need to be careful to introduce all the basic details that can remove vagueness from the charge sheet. For example, date of the incident. If it is any particular incident or multiple incidents, then all the incidents possible. Specific date of its occurrence, time of its occurrence. If you're not very clear of the exact time, maybe an approx time, but then it has to be in and around that time. If it is like 2 days later, it is something that has happened, then that is again challenging allegations against the delinquent employee. So is the location of the incidents as well as details of the incidents. So these things has to be mandatorily there in the charge sheet. The charge sheets should also clearly state which are the provisions that has been violated. For example, it's not just the date, details of the event, but it should also be very clear that by indulging in this particular act, which happened on this day, this time, this place, by indulging in that act, you have violated this particular clause of either our internal rules or regulations, or something in your employment contract which was mentioned, or in the standing order. So you have to also be clear ki which specific law or which specific clause within his employment contract or rules within the organization or standing orders have this person violated. Now, if you are clear what he is violated, this allows the delinquent employee to fully understand the basis of the allegations, and it gives him a reasonable opportunity to defend himself or herself. So that's another principle. Please state according to which particular provision is we calling it a misconduct. Also, the charge sheet should be drafted in an impartial and unbiased manner. So, if you write a charge sheet in which you write that we have received solid evidences which says that you have conducted this particular event or particular act which is clearly a misconduct according to us. Hence, we are calling a domestic inquiry which you come, which if you have any proof, try defending it. Let's see. If this is the language, any person who reads this charge sheet will understand that already the employer thinks that this person have committed this mistake, and this is a mere formality, the conducting of domestic inquiry, and that can be a basis of cancelling, or rather the court squashing the entire domestic inquiry proceedings. So it should be neutral, and if it sounds neutral, suddenly the assumption that principles of natural justice and guaranteeing a meaningful and substantive disciplinary inquiry is going to happen. So in the Surendra Chandradas versus State of West Bengal case, the delinquent employee prayed for quashing his order of suspension on the ground that the inquiry was merely a show off, as the language of the charge sheet indicated that the disciplinary authority have already drawn conclusion that he was guilty of the misconduct. So the court in this case quashed the order of suspension passed by the employer against the delinquent employee. So maybe he would have done this. There is clear proof, but he is defending that the committee or the inquiry officer was partial from the beginning. From the beginning itself, you were partial. That is enough ground for court to believe that this inquiry was not correct. All the relevant documents mentioned in the charge sheet should be disclosed with the delinquent employee. Now, this becomes extremely challenging in sexual harassment cases, where the complainant might produce certain sensitive proof, which includes some sensitive photographs of herself. But she is producing her because there is a clear evidence of a person indulging a harassment, and we still have to share this particular information with the delinquent employee, because, as I said, to ensure natural justice, he should also get his right to defend himself against allegations made against him. So you have to, if you have mentioned a particular evidence or a document in the charge sheet, they have to be disclosed with the delinquent employee also. So, so it is reported against you that no, your manager has reported against you this particular report, and it is found in that report that you are a culprit. That report also has to be attached. Another principle that need to be followed is that charge sheet must contain time for submitting explanation to charge sheet. So you give this charge sheet to the delinquent employee, and the employer should give some time to this delinquent employee, usually 2 days, 3 days, depending upon what the employer feel is a enough time for the respondent, or rather the delinquent employee, to give a response to the showcase notice. Sometimes uh, both the party knows ki you don't need much time to respond to this, that case it is fine. But some, if the delinquent employee asks for some time extra, I think it's a good practice that you can allow it for one time, and then further requests can be denied. You could always argue that if he actually wanted that much time, he would have known it in the first instance itself, and enough leniency has already been shown by the employer, and all those things can be argued later. So it's best that you give a 2 days notice, and then until and unless there is some specific provisions within your rules or regulations or standing orders of the specific state, or if it is a POSH complaint, sexual harassment complaint, until unless it's a 2 day where you can give time, and if the delinquent employee asks for more time, you can probably grant a reasonable time extra. So that also has to be provided to the delinquent employee. With that, let me conclude today's session. So, taking a recap of what we have discussed, we have seen how important it is to have a charge sheet ready, and the charge sheet or the showcase notice has to be provided to the delinquent employee before starting the proceedings. There are clear case laws in which employees have argued that I was not given a charge sheet, but I was given a showcase notice. Hence, this domestic inquiry is not valid. But the court have said that any of them is good enough. So that's why I'm using both these words interchange. Charge sheet is the proper word. So we have seen how to draft it, what are the components to be included in the charge sheet, and we have seen some of the basic principle that you need to keep in mind while you are writing, or in the tone of the charge sheet. So with those information, I'm sure now you are in a comfortable position to draft a charge sheet. Maybe you can try writing one for my various. There's theft that has happened. There is a particular instance of damaging the property has happened, or maybe a situation where employee has been coming very late, repeatedly, and you have issued a showcase notice. So we can try all these combinations, and maybe you can send it to me, and I'll give it a good look and tell you that how good you are now in drafting charge sheets. With that information, with that knowledge, I think let's take a break as of now. We'll join back for the next session, which would be on how to conduct domestic inquiries. Probably we might have the session extended into two sessions. So once you have an idea of domestic inquiry conduct, you will have a fair legal understanding of how to handle misconducts at workplace. So with that note, let me take a break. You have a great day ahead. Thank you so much.